Right, I think we'll make a start. Good afternoon, everyone. Thank you for joining us for another Beale & Co webinar, the next in the series of our regular construction law updates. Many of you are regular attendees and will be aware of the format for these by now. Thank you for joining us again, and welcome to the new attendees. This webinar, as the title slide indicates, is in relation to alliancing, with a particular focus on the new NEC4 Alliance Contract, which NEC launched at the NEC Users Group annual seminar in London on 20th of June last year. The Alliance Contract is a new addition to the NEC suite, and it follows a consultation on the consultation form which was released in July 2017 to allow the industry to feed back. In the words of NEC, and I quote, "The contract marks the next step in NEC collaboration, creating a true alliance arrangement in which the client and all key members of the supply chain, called partners in the alliance contract, are engaged under a single contract." Just some quick introductions. My name is Will Buckby and I lead the Contracts and Projects Advisory team at Beale & Co. I'm joined by Andrew Croft, a senior associate in the team. Today our webinar is split into two parts. During the first part, I'm going to talk about alliancing generally, including what is alliancing, why it is relevant and increasingly popular, and when it should or shouldn't be used. I will also look at the uptake of alliancing in the UK construction and infrastructure sector. I then intend to look at what a pure alliance is, including what an alliance agreement looks like when pure alliancing is adopted. Before I hand you over to Andrew, I'll then briefly mention, in addition to the NEC4 Alliance Contract, other standard alliance agreements which are currently being used in the UK construction and infrastructure sector. Andrew will examine the NEC4 Alliance Contract in some detail, including focusing on the nuts and bolts, the standard form and the key concerns. Given that alliancing is new to some of you and that the NEC4 Alliance Contract is a new form, we're expecting lots of questions. As usual, questions can be raised during this webinar using the interactive box on your screen, or do email us at our email addresses on the slide. We'll leave the questions probably to after the webinar and revert to each of you individually or collectively, depending on the nature of the questions. We've got quite a lot to get through. So what is alliancing? I think it's easier to start by explaining what alliancing isn't. Alliancing is more than a simple consortium or joint venture. It's also more than partnering. In the NEC context, it's much more than the collaborative approach which the NEC state goes to the core of their contracts through the requirement for the parties to act in a spirit of mutual trust and cooperation under clause 10.2. Alliancing is more than the collaboration which can be achieved through use of NEC4 secondary option X12, which incentivizes multiple suppliers to collaborate and achieve a common set of objectives. Whilst the NEC3 guidance on implementing alliancing using NEC3 contracts published in November 2016 suggested that alliancing could be achieved using secondary option X12 in contracts with each alliance partner, consultants, contractors, key suppliers and other members of the supply chain, it did acknowledge that there would need to be amendments to the standard allocation of risk under the NEC3 forms, so not achieving true alliancing using option X12. Alliancing isn't achieved through the ICC partnering addendum introduced in 2011, and which in fact has now been superseded by the 2014 forms. The addendum was designed to be added to each two-party ICC contract and provides for a core group to reach decisions by unanimous vote, requires a consolidated programme and requires joint risk management and KPI arrangements, amongst other things. Alliancing is more than the approach adopted in PPC 2000, which, as stated in the accompanying guidance notes to the form, is a single fully integrated standard form project partnering contract designed to underpin a team-based approach among partnering team members. These agreements or addendums are focused on collaboration or partnering in the construction and infrastructure sector. Alliancing goes further than this. So what is alliancing? Alliancing in general terms can be described as a single agreement where a collaborative and integrated team is brought together from across the extended supply chain, and the team shares a set of common goals which meet client requirements and work under common incentives. Typically, it will be where the client partners, the supply chain, and in some cases stakeholder groups, are all part of the alliance contract and aligned with agreed outcomes. Importantly, under the alliance agreement, risks are typically shared, as is commercial return, and the parties to the alliance agreement are aligned so that the interests of all participants are as equal as possible, and also importantly, the level of integration is high. The European Construction Institute, I think, summarises alliancing well. It has stated that alliancing is a form of long-term partnership on a project or programme of works in which a financial incentive scheme links the rewards of each of the alliance members to specific and agreed overall outcomes, and in which all aspects of the arrangement are incorporated in legal binding contracts. So why this webinar on alliancing, and why the NEC4 Alliance Contract amongst other recent standard forms? The Infrastructure Client Group, in its 2014 publication, Improving Infrastructure Delivery, Alliancing Best Practice in Infrastructure Delivery, provided that the benefits of an alliancing approach to the collaborative delivery of significant construction projects are now clear. In the right environments, the benefits alliancing delivers are considerable. So just to build on this, the publication commented that alliancing is perceived as particularly beneficial where there is a complex environment with multiple stakeholders, with competing interests, but importantly, common goals. The idea is that creating an alliance contract will help collaboration and enable better performance. Similarly, it's viewed as a good tool for achieving performance improvement and changing behavioural patterns. Alliancing is also popular where there is an extended supply chain. Innovation of some form is required, and where there is a need for direct customer access through the supply chain. Experience tells that alliancing tends to be effective on larger and longer term projects or programs. There is a setup and overhead cost to alliances that can restrict their effectiveness on smaller projects. As the program or project size increases, however, an alliance is then able to deliver enhanced value over and above traditional procurement routes. Time is also required to build the relationships and trust required within the alliancing chain, which means that alliancing is more likely to suit longer term projects. Alliancing is now very much a buzzword, but the industry and Beale & Co have been talking about it for some time. It was first adopted by British Petroleum in the 1990s in an attempt to reduce the development costs involved with drilling for oil in the North Sea. The first notable alliance was the Andrew oilfield project. This was a complex and challenging technical project and demanded significant cost savings over traditional methods of delivery to make it economically worthwhile. It has been well publicised that the Andrew oilfield project delivered significant time and cost savings for BP. Alliancing was subsequently used by the public sector in Queensland, Australia, particularly in oil and gas projects, and it is now being used widely across Australia and New Zealand on some mega schemes. In the UK, National Grid, Network Rail, the water industry, and various local authorities have used or are using alliancing, and this is with some success. Highways England have recently moved to the alliance procurement model and to the NEC4 Alliance Contract for its 4.5 billion Smart Motorways Alliance. The infrastructure client group has commented that there is now an industry-wide track record that supports the business case for alliances. So it looks like alliancing is here to stay and may become even more popular. Now, alliancing can clearly take different forms, and various different forms of alliance have been procured in recent years. With the background which I've just provided, we thought it would be of use to explain in some detail the key components to a pure alliance, a true alliance. Pure alliancing is an approach which has been adopted by many of the major infrastructure employers. Network Rail in particular have been advocates of pure alliancing, and Andrew and I advised on Network Rail's first pure alliance. To some extent, the NEC4 Alliance Contract achieves pure alliancing, and Andrew will focus on this shortly. So in the context of the construction and infrastructure sector, a pure alliance is where two or more parties, the client, lead consultants, contractors, enter into a project alliance agreement to form one team to deliver the project or a series of projects. Importantly, in addition to the consultants and contractors delivering the project or projects, the client will play a key role in project delivery. The project alliance agreement will deal with the obligations and liabilities as between the consultants and the contractors, together the members, and as between the members and the client. So the agreement deals with horizontal and vertical contractual matters. The overall driver for the project alliance agreement is that the parties, the client, consultants, and contractors collaborate to achieve a common goal. And as I will demonstrate, a key feature of alliancing is that the project team wins together and loses together, and at the same time acts in the best interests of the project, not their own interests. It is typical to alliancing that the members are jointly and severally liable to the client for any breach of the project alliance agreement. And this is an excellent example of the win together, lose together notion which I mentioned. Under the joint and several liability arrangement, any of the members could be liable for the other's breach, even if the member has not contributed to the liability. One advantage of such an arrangement is that it encourages the parties to collaborate, as they clearly have a vested interest in assisting the other members. Where joint and several liability amongst the members exists, it is important that members agree the basis on which liability for any claim is apportioned between them, and include a mechanism in the alliance agreement to achieve an agreed apportionment. One way of apportioning liability is to say that any any liability, whether to the client, a third party, or another member, will be shared equally, regardless of fault. This is the true win together, lose together scenario, as notwithstanding how the losses arise, they are shared by the parties. Clearly, this raises some difficult insurance considerations. Cross indemnities as between the members serve as a useful tool to ensure that the division of risk is in accordance with the agreed shares, and the cross indemnities need to be drafted very carefully. Clearly, joint and several liability is not always appropriate, and it is not a risk which can be stomached by all. Another approach is for each member to be severally liable to the client, and this works particularly well where there is a distinct and segregated scope within the project alliance agreement. In our experience, this approach probably doesn't reflect a pure win together, lose together philosophy. However, it is common. Project alliance agreements often provide for the setting up of an alliance leadership or management team. This comprises representatives from each of the alliance members, including the client, and provides strategic direction for the alliance. Importantly, it is usual for unanimous agreement to be required before the management team can make decisions, and there is usually no deadlock drafting. This is another example of how the win together, lose together approach is reflected in the alliance agreement. If the parties are unable to agree the decisions together, the risk is that the progress of the project will be stunted and the overall future of the project put in jeopardy. In such situations, the parties lose together. On the other hand, if they can agree all management decisions together, the project will progress and hopefully be successful, i.e. win. But achieving unanimous decisions can be problematic, particularly given the number of parties involved. The members will, of course, have different interests to that of the client, and the contractors may have alternative interests to the consultant, for example. Deadlock provisions can resolve any situation where agreement cannot be achieved, and we do see this drafting. However, deadlock drafting is considered to contradict the win together, lose together notion, as they could result in some members of the alliance achieving a different solution to that sought by another. It is normal for the scope of the project alliance agreement, that works and services required to be delivered, to be integrated, with the members and the client delivering the project as one entity. Pure alliancing, true alliancing, usually sees the management team deciding on what elements of the scope are best delivered by the most appropriate personnel of the alliance. And this is different to the segregated scope which I mentioned earlier. Under project alliance agreements, where there's true pure alliancing, the members are generally paid on a target cost basis, which is collectively agreed by the members at the start of the project. In other words, there's one target cost and a collective gain share and pain share mechanism. If the alliance members' total reimbursable costs are less than the target costs, they share any savings, and the members are entitled to a gain share amount. Whereas if their total reimbursable costs exceed the target costs, the losses are shared between the alliance members, and the members must pay the client a pain share amount. So this is another example of the win together, lose together notion. Whilst a clear advantage of this payment mechanism to the client is that it aligns the profit recoverable to the success of the project and encourages the members to work in a way which benefits the project as a whole rather than the members' individual interests, there are real risks to the members. The members have limited control over whether they ultimately make a profit, and they may become liable for pain share, say solely as a result of the actions of another alliance member. A distinguishing feature of alliance agreements and another embodiment of the win together, lose together approach is a commitment to a no blame, no claim culture, including an agreement that the alliance members, as well as the client, will not commence proceedings for any breach of the alliance agreement, except in limited circumstances, such as on termination for material breach, willful default, and non-payment. This is attractive to clients as it encourages parties to focus on resolving issues by negotiation and discussion as and when they arise, which should reduce delays and additional costs as a result of any dispute. It's also appealing to the members as there will be limited situations where claims can be brought against them. Collectively, the client and members may also be more willing to be open and collaborate without the fear of proceedings. However, as I have identified, there are often a number of exclusions from the no blame, no claim position, and therefore the members could potentially incur liability in connection with the alliance. So this is not a true no blame, no claim culture position, and the parties should not assume that there is one. There are also some interesting dispute-related issues which need to be borne in mind by members arising out of this no blame, no claim approach. Given the major infrastructure projects for which alliance arrangements are typically used, at least some of the agreement will be a construction contract for the purposes of the Construction Act. And the operation of the Act would mean that certain statutory provisions would apply, including those relating to adjudication, payment, and suspension. Given the members' agreement that there will be no claim between them, issues may arise on a project in relation to dispute resolution, given that the parties cannot exclude rights, say, to adjudicate. Now, alliance agreements typically cover all aspects of the relationship between the parties, including both the traditional construction elements, which are relevant to the Act, and the collaboration and joint venture type provisions. The Act applies only to construction operations, and its application is limited where a contract relates partially to construction operations and partially to other elements, such as the joint venture type obligations. It will be interesting to see whether members are willing to test the application of the Act in this manner. For example, would a right to adjudicate be pursued in respect of the collaboration type provisions, including, for example, unanimous decision making, pain, gain share provisions? We're not aware of any such adjudications. Under alliancing agreements, the members will often agree to act in good faith in performing their obligations. This is clearly to encourage cooperation and help establish the win together, lose together approach. Further, alliancing agreements often also include an obligation to act in accordance with an alliance charter, which sets out a number of shared project goals. This reflects the win together, lose together approach, which I keep mentioning, as it encourages parties to work and behave in a way which best benefits the project. However, Charters often contain vague requirements, which are aspirations rather than clear obligations, and reflecting this in the drafting can be problematic, certainly for the lawyers. It is common that such terms are subject, unfortunately, to disagreement and misunderstanding as to their interpretation, which has the potential to cause a dispute. It's a good example of where the project team and the lawyers need to be joined up. So that is the approach to pure alliancing. As promised, Andrew will very shortly be talking about the new NEC4 Alliance Contract. Before he does that, I thought it would be useful to highlight quickly other alliance agreements in the market. In 2017, the ACA, in conjunction with King's College, published the TAC1, the Term Alliance Contract. And the same group published the FAC1, the Framework Alliance Contract, which came out in 2016. As expected, the forms are similar in approach and style. To give you a flavour, the FAC1 describes itself as the first standard form framework alliance contract. For those familiar with PPC 2000 and TPC 2005, FAC1 feels similar. It is a multi-party overarching agreement between any number of framework alliance members and provides for the award of individual contracts forming part of an agreed framework programme. As expected from an alliance agreement, common objectives, success measures, targets and incentives. A timetable for stages in the framework programme and shared activities. And joint commitment of alliance members to work beyond the scope of individual project contracts in seeking to achieve improved value. Key features include a shared overarching brief among all alliance members, an alliance manager integrating the alliance, monitoring performance and supporting joint activities, links to BIM and strategic asset management, and a core group to review new proposals and agree on dispute resolution. The ACA forms don't go as far as pure alliancing and are probably a rework of the collaborative concepts in PPC 2000. Nevertheless, they demonstrate a real shift to collaborative working in our industry. It is also worth noting that some of the big infrastructure employers now have a standard bespoke, if I can call it that, alliance agreement. For example, Network Rail, which seeks to adopt the pure alliancing approach I have mentioned. So I'm now going to hand you over to Andrew, who will concentrate on the NEC4 Alliance Contract.
Thank you, Will. Now that we've taken you through some of the background to alliancing as a concept, I'll have a look at the NEC's approach to alliancing in the NEC4 Alliancing Contract, which is also referred to as the ALC. Before I do so, some background to the NEC4 Alliance Contract. An NEC form of alliancing contract has been rumoured for some time, given the NEC's general collaborative approach. Indeed, in March 2011, almost 7 years before the final alliance contract was published, the Treasury's Infrastructure Cost Review Implementation Plan advised that an NEC3 alliance contract was being considered. However, it was not until the NEC4 suite of contract was published in June 2017 that an NEC alliance contract first saw the light of day, and even then it was in consultation form only. The final version of the alliance contract was finally published in June 2018. As Will mentioned, there's been significant uptake of alliancing on UK infrastructure projects, and given the NEC suite's position as one of the most popular forms of contract in the public sector, being endorsed for public sector use in the UK government construction strategy, it's not a surprise that we are already seeing uptake of the NEC4 alliance contract in significant infrastructure projects. For example, as Will mentioned, Highways England is using the Alliance contract for its 4.5 billion 10-year Smart Motorways Alliance, and the NEC4 Alliance contract is also being used to deliver an estimated 1 billion of mechanical, electrical, heating, ventilation and air conditioning services on Hinkley Point C. So, what do the nuts and bolts of the NEC4 Alliance contract look like? The general contractual structure will be familiar to users of the NEC3 and NEC4 contracts. The Alliance contract still includes the key elements of an NEC contract, such as the core clauses, the secondary X option clauses, Z clauses for any amendments, the schedule of cost components, and contract data part 1, which is the client and alliance data, and part 2, the partner data. The Alliance contract also includes core NEC provisions, such as the spirit to act in mutual trust and cooperation, the detailed program obligations, the defects obligations, the early warning regime, and the compensation event regime for variation. However, before you get too comfortable, these mechanisms are not quite as you know them in the NEC4 Alliance contract. For example, there is no time bar for notification of compensation events, and no requirement for programs to be accepted. In addition, the secondary X options included in the NEC4 Alliance contract for selection are limited. As I will discuss, some key secondary X options are not included, and those which have been included have been amended. So, although experience of the NEC forms will certainly be helpful in administering the ALC, it will still be important to be fully up to speed with the way the key mechanisms have been adapted for the ALC at the outset of any contract. There are also a number of additional obligations and provisions in the NEC4 Alliance contract, including the key obligations which apply to the Alliance. Under the ALC, the Alliance is comprised of the client and the partners, as identified in the contract data part 2. So the partners is essentially the delivery team. The client and the delivery team are required to collaborate to achieve the Alliance objectives and the partner objectives, and also provide the works in accordance with the scope, Alliance objectives, and implementation plan. This underlines that, as is typical in pure Alliance contracts, the NEC4 Alliance contract makes the client and the delivery team responsible for achieving key objectives and providing the works. This means that the client has real interest in assisting the works to be complete, as required by the contract, amongst other things. The client and the delivery team are also required to act in a way that is best for a project, rather than in a way that is best for their own interests, and also to provide advice fully, openly, and objectively. This emphasizes the need for a real change in mindset, culture, and ways of working under the NEC4 Alliance contract, for it to work in the way envisaged by the contract. These obligations also identify 2 key documents which are required under the NEC4 Alliance contract: the scope and the implementation plan. As under any other NEC forms, the scope is to specify and describe the works and state any constraints on the works. One additional requirement for the scope under the ALC is that it is to contain what's called the client's requirements for the works. I'll comment on these later. The implementation plan is more of a framework for how the administrative and management functions of the alliance will operate, such as the management structure, roles and responsibilities, and delegation by the alliance board. The implementation plan will be a very important document to determine how an alliance will function on a day-to-day basis. Another new and key aspect of the NEC4 Alliancing Contract is the Alliance Board. The Alliance Board is made up of one representative from each member of the Alliance and is described by the NEC4 User Guide on Managing Alliance Contract as being at the heart of the Alliance and being the key decision-making body setting the structure and direction for the Alliance. The Alliance Board is to meet at the period stated in the contract data and whenever required by a member of the Alliance. The importance of the Alliance Board is shown by its role under the NEC4 Alliance Contract, which includes setting the strategy for achievement of objectives, allocating work, appointing and instructing the Alliance Manager, and ultimately resolving disputes. I'll comment on disputes further shortly. The Alliance Manager manages the Alliance on a day-to-day basis on behalf of the Alliance. This includes preparing and updating the programme, applying for payment, providing forecasts of costs and time, and assessing compensation events, i.e. whether a compensation event has arisen and what the impact is. So, the Alliance Board and the Alliance Manager are two key functions of the NEC4 Alliance Contract. It is important to note that for the Alliance Board to make a decision, agreement of all members is required, i.e. agreement of every individual from the Alliance, save in respect of limited circumstances, such as termination. This is a common position in pure alliance agreements, but without any deadlock resolution mechanism could create difficulties, as I will discuss shortly. So, how does payment work under the NEC4 Alliance Contract? The partner's main entitlement to payment is to define cost and the fee. As usual on NEC contracts, defined cost means the cost of the components in the schedule of cost components less disallowed cost. Disallowed cost is very widely defined in the NEC4 Alliance Contract as being a cost not justified by a partner's accounts and records. This means that it will be very easy for payment to be deducted for minor failure to justify defined cost. This is particularly the case due to the detailed information required by the schedule of cost components, including all payments made to any person in accordance with their employment contract. As shown by a note on our website, which we will circulate to attendees, the implications under GDPR of these requirements to provide personal data should be carefully considered. Our concerns in respect of defined cost and disallowed cost are emphasised by the fact that payment is essentially on an open book basis under the ALC, i.e. records of all defined costs and payments must be kept and made available for inspection by the Alliance Manager and the client. The payment regime will need to be handled with care. Perhaps surprisingly, the payment regime under the NEC4 Alliance Contract does not include the target cost mechanism, i.e. options C and D of the NEC4 Engineering and Construction Contract. Pay and gain is usually a central part of the payment regime in a pure alliance contract, as Will mentioned. Instead, the NEC4 Alliance Contract provides for payments to be adjusted based on performance measurements by reference to the performance table, which is to be set out in the Contract Data Part 1. The two types of performance measurement to be set out are based on 1. Targets for achieving alliance objectives, and 2. Budget savings or overspend. Budget savings and overspend are determined by whether the alliance cost is greater or less than the budget stated in the contract data. If an alliance objective is met or a budget saving achieved, the partners are paid a sum as set out in the performance table. If the alliance objective is not met or there is budget overspend, the partners are required to pay a sum, again as set out in the performance table. The performance table is therefore a key document for understanding the payment regime under any NEC4 Alliance contract and will need to be considered carefully. The NEC4 suite included a complex regime to allocate liabilities between the parties, with the parties required to reimburse each other for costs incurred as a result of an event that was their liability, which is akin to an indemnity. The NEC4 Alliance contract also includes a liabilities regime. The client and partner liabilities are one of the few exceptions to the no-claim position under the ALC, which I'll comment on shortly. Both the partner and client liabilities include an intentional act or omission by the partner or the client to not comply with their obligations. This appears to be trying to capture the concept of willful default, which is commonly carved out of any no-claim culture in a pure alliance contract. However, the scope of this willful default provision under the NEC4 Alliance contract is much wider than we would typically want to see, and not completely clear. For example, it is not expressly stated that the act or omission must occur with an intention and an understanding that it is a breach of the alliance contract. In addition, there is no requirement that the partner or client appreciated the risk of the act or omission before proceeding. In our view, this is unhelpful drafting. The other client and partner liabilities are fairly limited in scope. The client liabilities are issues occurring after takeover and damage to other client property other than that caused by the work, and the other partner liabilities are breach of intellectual property and death or personal injury to employees. These are not unreasonable. However, the willful default position is a risk. The NEC4 Alliance contract also includes provisions for insurance to be taken out, including requirements for the core insurance policies one would typically expect to be taken out. Essentially, CAR insurance in respect of the works, plant and equipment, public liability insurance in respect of third-party property damage and injury, and employers' liability insurance. All members of the alliance are required to maintain employers' liability insurance. The other insurances are required to be taken out by the client, unless otherwise stated in the contract data. The minimum levels of cover and the deductibles under those policies are also to be stated in the contract data part 1. The NEC4 Alliance contract is, however, silent on professional indemnity insurance. This is not unusual in a pure alliance contract, as claims in respect of design issues, which professional indemnity insurance is typically intended to cover, would in theory be inconsistent with the no claims position. There is scope for professional indemnity insurance and other additional insurances to be required under the NEC4 Alliance contract, as additional insurance can be specified in the contract data. Under an alliance contract, other project type insurance may also be required, such as integrated project insurance, for example. If this is the approach, it is likely that the ALC would need to be amended for consistency with the relevant policy. One key point in relation to insurances is that all provisions or policies are required to include a waiver of subrogation against the alliance members, other than where there is fraud. This reflects the no claims position under the ALC, although there is some inconsistency here, as I will cover shortly. It will be important to confirm with insurance advisors that any policies to be maintained by you include such a waiver of subrogation. A final point in relation to insurance is that if any sums are recovered from an insurer, they will not be an alliance cost, so it will not be taken into account in determining any budget savings or overspend. This will need to be borne in mind when considering the budget and during the course of the contract. One of the most significant departures from a typical NEC contract in the NEC4 Alliance Contract is the approach to dispute resolution. For perhaps the first time in a standard contract, the ALC includes an agreement that 1. Breach of the contract does not give rise to enforceable rights except for client and partner liabilities, and 2. Disputes can only be resolved in accordance with the alliance contract. This is not an unfamiliar position under a pure alliance contract, as it reflects the collaborative approach that is central to an alliance. However, it is a real departure from the typical approach in construction contracts. If a dispute does arise under the NEC4 ALC, the main course of action available is to refer it to the Alliance Board for resolution. As commented previously, unanimous agreement of all members of the Alliance Board is required for the Alliance Board to make most decisions. And if a dispute has arisen, by definition, it will not be easy for agreement to be reached by all the parties. The Alliance Board can refer a dispute to an expert for an opinion, if agreed by the Alliance, or refer it to senior representatives of each member of the Alliance who have 4 weeks to resolve the dispute. However, these mechanisms have no real teeth. For example, the independent expert's opinion is to be used to assist in finally resolving the dispute, but is not binding. And whilst the senior representatives can appoint a mediator if agreed, this is essentially an agreement to agree. Alliance in convert would suggest that the lack of a final dispute resolution method, other than reference to the Alliance Board, is a positive thing, as it will encourage a collaborative approach. However, it is a completely different approach to that which we are used to. I should say that the no claims position in pure alliancing agreements has not been tested by the courts, and there are some who doubt the effectiveness of them in ousting the court's jurisdiction. There are a few exceptions to the no claim position in the ALC. Firstly, as shown on the slides, the waiver of rights does not include the client and partner liabilities. However, any dispute in relation to the client and partner liabilities can only be resolved in accordance with the alliance contract, which only permits disputes to be referred to the Alliance Board, so the effect of the exceptions is unclear. We also typically see wider exclusions from the no claims position, such as fraud and claims following termination. Indeed, there is inconsistency between the no claims drafting and the waiver of subrogation required in insurance policies, which I just mentioned, because the waiver of subrogation refers to fraud, whereas this exception does not. Another common carve-out or area of dispute in relation to the no claims position is how it fits in with the position for non-payment and the right to adjudicate, which cannot be excluded if the Construction Act applies, as Will commented. This is reflected in the NEC4 Alliance Contract. If option Y UK2 is included, the members of Alliance will have a right to refer a dispute to adjudication at any time, whether or not it has been referred to the Alliance Board. However, if option Y UK2 does apply, in our view, the extent to which disputes can be referred to adjudication is unclear. This is because there will be conflict between the right to adjudicate and clause 94, which is shown on the slide. This is more unfortunate drafting in the NEC4 Alliance Contract and a risk. We would therefore suggest that further exclusions to the no claim position in respect of non-payment, for example, and fraud, amongst other things, are considered if the NEC4 Alliance Contract is used. There are also some key risks under the NEC4 Alliance Contract, which I'll cover now. Firstly, as I've commented previously, the majority of decisions of the Alliance Board must be unanimous. Failure of one member of the Alliance to agree will therefore prevent a decision being made. There is no mechanism for resolution of deadlock of the Alliance Board in the NEC4 Alliance Contract, so the only option, if a decision cannot be made, would be under the dispute resolution process just described. Given the lack of teeth in this process, and the requirement that disputes are referred to the Alliance Board again, this will not assist to resolve the deadlock. Due to the central role of the Alliance Board to the operation of the Alliance, there is therefore a real risk that failure of the Alliance Board to make a decision could cause significant delays to the Alliance, including to the progress of the works, the issue of a defect certificate, and therefore final payment, and acceptance of a compensation event quotation, for example. This position is a common risk of pure alliance agreements, with the lack of a fallback position intended to encourage agreement. However, given the potential risk of deadlock of the Alliance Board, it would be sensible to consider some form of deadlock mechanism. Another key risk under the ALC is that the obligations of the Alliance include potential fitness for purpose obligations, and perhaps even encourage fitness for purpose obligations. The Alliance is required to comply with the Alliance objectives and the scope, and as I mentioned, the scope is required to include the client's requirements as a new section. It is likely that the objectives and/or the scope will therefore include performance requirements. This is emphasized by the NEC user guide, which, as quoted on the slide, suggested that for a contract in respect of a water treatment plant, the scope could include the minimum volume of water and the quality of water required. The risk of fitness for purpose obligations is underlined by the fact that the secondary X options, which can be selected in the ALC, do not include NEC Engineering and Construction Contract option X15, which limits liability for design to reasonable skill and care. Fitness for purpose obligations are a common concern under pure alliance contracts. This is because they are difficult to comply with and inconsistent with typical professional indemnity insurance, so are a real risk. From our experience, it is sometimes possible to agree exclusions for fitness purpose in respect of design in alliance contracts, and we suggest that an express exclusion for fitness purpose is requested under the ALC if possible. A similar risk under the ALC is design responsibility. The ALC, the Alliance, appears to have wide design responsibility, as it is responsible for providing all design necessary to provide the works. However, there is no duty of care in the Alliance contract, which increases the risk of fitness for purpose obligations and creates the risk that strict obligations may arise. In addition, there is no standard NEC limit of liability for defects in the design. There is therefore a risk that design obligations under the ALC may be inconsistent with professional indemnity insurance, and amendments should be considered. Another risk under the ALC is that the compensation events are very limited, as set out on the slide, much more limited than, say, under the professional service contract or the engineering and construction contract. For example, they do not include failure to comply with a program, physical conditions, adverse weather, or breach of contract by the client. This limited variation entitlement is not uncommon on pure alliance contracts. However, the key risk is that because of the limited compensation event regime, there are limited circumstances in which the alliance will be entitled to changes in the budget, the performance table, and the completion date, which will make it more likely that the alliance or the partners will be required to pay payments to the employer under the performance regime. It should therefore be considered that the compensation event should be expanded by stating additional compensation events in the contract data. Another key risk under the ALC is the approach to liability and limiting liability. Firstly, unless secondary option X18 is included, liability will be unlimited and there will be no end of liability date. In addition, even if X18 is excluded, liability for payments in the performance table will be unlimited as that liability is carved out of the limit of liability. This is a risk, and it is typical on alliance contracts for liability for pain to be capped at the fee, for example. Another point to highlight is that the option X18 does not include other standard limits of liability that you expect to see in the NEC option X18, such as in respect of indirect loss, defects in design, and damage to client property. Another point in relation to liability is that under the ALC, the liability of the partners is essentially several, and there is no aggregate limit on the partner's liability as a whole. There are simply separate limits of liability for each partner if option X18 is included. It is common for aggregate limits of liability for the alliance as a whole to be agreed in alliance agreements. Finally, the complex liability regime, which I mentioned previously, also appears to require a partner to pay costs incurred as a result of that partner's liability to another partner under clause 83.3. The drafting is far from clear and difficult to follow, but this appears to create some intra-partner liability. And liability between the partners is unlimited under the ALC. Finally, the final risk that I wanted to discuss was the performance measurements, which I've touched on quite a lot already. The main point, which I haven't already mentioned, is that under an alliance contract it's typical for pain/gain to be shared by the alliance as a whole, i.e. the delivery team and the client. Under the ALC, only the partners are required to pay sums under the performance table. So it's unclear how the client shares in this performance regime. And for example, using the default position, it suggests that the partners could be required to share all budget overspend. It's therefore important that the liability regime in the performance table is considered very carefully before the ALC is entered into. I'll now hand over to Will for some concluding thoughts.
Thanks, Andrew. So it's almost 1:30. Given the limited time, I just thought we would plug some upcoming webinars that Beale & Company delivering in June and July. We have a number of webinars approaching as part of our regular construction law updates. The 13th of June, Anna Braden will provide an introduction to arbitration, and on the 27th of June, Claire Miller and Sadaf Habib will provide a practical perspective on arbitration. That's on the 27th of June. On the 4th of July, Sam Johnson will be delivering a webinar on how to manage payment from developers, and we have chosen this topic because we've seen an increase in advice and support required where developers have not paid our consultant and contractor clients, and this is definitely a theme of the last 6 months. So if you wish to join these webinars or require further information, please do register at the address shown on the slide. That's webinars@beale-law.com. So Andrew and I have provided a summary of alliancing and its current position in the UK construction and infrastructure market. And Andrew's gone into quite a bit of detail in relation to the NEC4 Alliance Contract. I think the NEC4 Alliance Contract embodies much of the pure alliancing approach. However, there are some key areas that need to be looked at, some key risks which Andrew has mentioned, include the deadlock position, fitness for purpose, design liability, compensation events, and the liability position. So it is recommended that, despite this being the NEC4 standard form, that it is looked at carefully and legal advice is taken. So it remains me to say thank you for listening to me and Andrew this afternoon. If you've got any queries in relation to any of the items we've discussed, including in relation to alliancing generally or the NEC4 Alliance Contract, please do not hesitate to get in contact with us. The details are on the screen. We've had a few questions already in relation to availability of the slides and recordings, and we will circulate these very shortly. We'll also respond to the questions. And once again, thank you everyone for listening, and goodbye.